you so much for that terrific introduction, David, and for inviting me to participate in this conference, and to Max and Chris and Debbie and everyone at AV at Arnold Ventures for making this possible. I'm delighted to be here today, again, to talk about this important topic of corporatization in healthcare. But in particular, I'm going to kick it off with a discussion about consolidation. So let me, if you bear with me, I will share my screen, and then I will begin the discussion. All right, so I'm discussing today how consolidation among healthcare providers and payers, the insurers that pay for care, are contributing to the corporatization and rising healthcare costs that we're seeing across the healthcare sector. In addition, I'm going to highlight some policy options that states will be looking to address this issue as it emerges within their borders. And I think that a lot of states are just starting to be on the leading edge of some of these efforts. I'll highlight some of these innovations. First, I'm going to just dive into how healthcare consolidation really is the key driving force behind rising healthcare costs, which, if you're tuned into this conference today, I'm sure very well aware from wherever you sit, from purchasers, from citizens, from employers, from providers. Everyone is struggling with the rising cost of healthcare. And the root cause of the rising cost, or the prices of healthcare, are these high prices driven by consolidation. So healthcare costs, like any other, are a function of price multiplied by utilization. But the key reason that the US spends so much more than Japan or any other wealthy developed country is because our prices are higher. It's not because we use more care or that we are particularly more adept at more sick or have a sicker or older patient population. So let's dive into healthcare consolidation. So healthcare consolidation has been rampant for the past few decades. It's only continuing. Sometimes the consolidation is sort of an obvious case where two hospitals in the same geographic area in the same city merge. That's a classic example of a horizontal merger. But increasingly, we're seeing consolidation is occurring through other channels. For example, you may have seen headlines about Amazon or CVS making multi-billion-dollar acquisitions of physician groups, or health plans like United, which operates Optum, or Humana forming joint ventures or acquisition partners for healthcare providers, primary care practices, healthcare data analytics, pharmacy benefit managers, and the like. So these are all forms of consolidation that are contributing to healthcare cost increases. And the buyers are not just the healthcare companies or institutions that we might recognize as incumbent players in the healthcare system. It's not just hospitals, and it's not just insurance companies, but also private equity firms and publicly traded companies like Amazon or CVS or Walmart are also making big investments, big moves in the healthcare space. So let's define first some of the terminology that we'll be talking about today. The first is this idea of a horizontal merger. A horizontal merger is that classic merger of direct competitors in the same geographic market. Hospital-hospital mergers in the same city. Horizontal consolidation could also entail physician practices, again, within the same geographic area. But we're also seeing the rise of vertical and cross-market mergers. Vertical consolidation involves a combination of two or more different steps in the supply chain. So in the healthcare supply chain, you might think of this as a hospital acquiring physician practices. That's a classic example of vertical consolidation in healthcare. But it also could involve the combination of a health insurance plan with a hospital system, or a health insurance plan buying up a large physician group, or a retailer making inroads into home health providers or data processing platforms. There are also, in addition to these vertical mergers, cross-market mergers, which involve mergers across geographic or product markets. So examples include large multi-state health systems that have grown across the country, the expansion of Catholic health systems across multiple states, the expansion and merger of Advocate and Atrium, from merging sort of a Midwest health system with North Carolina-based health system. So we see these growing trends of cross-market mergers And we also see private equity firms investing not just within a particular geographic area, but all across a state or region or across the country, particularly in a particular type of specialty practice. So historically, antitrust enforcers have not paid much attention to non-horizontal, that is vertical or cross-market mergers, because they believed the anti-competitive effects were either, modest or maybe mixed. But the evidence is starting to emerge that really all forms of consolidation are posing risks to competition, increasing costs, and decreasing access, particularly the healthcare space. So federal antitrust agencies are starting to take note, particularly in the 2023 merger guidelines, that these other forms of consolidation are also posing a challenge to competition. However, they have yet to notch a successful challenge in court to a cross-market or vertical healthcare transaction. So courts are the ones who, at this point, who are slow to adopt to this emerging trend. And so what are these trends? Nearly every major segment of the healthcare market is becoming more concentrated over time. This slide is actually based on data that's nearly a decade old, but it is indicative of a larger trend that I think has only worsened since this time. At the time of 2016, 90% of hospital markets, 65% of specialty physician markets, 57% of insurer markets, and 39% of primary care markets were already considered highly concentrated using measures that the FTC and DOJ use. These data are nearly, as I mentioned, a decade old. So this health system has only continued to consolidate further since this time. One of the biggest trends in this dramatic shift is the rise of vertical physician consolidation and the shift from physicians from independent practice to employment. Talk to any physician coming out of training today, they are likely not going to hang up a shingle or join an independent practice, but rather are seeking employment. And today, over 3/4, 77% of physicians are employed. They're employed by either hospitals and health systems or corporate entities. And due to this, the era of the independent physician practice is coming to a close. So 55% of physicians are employed by hospitals or health systems, and the other 22.5 are employed by other corporate owners. And these include private equity firms, insurers like United Health's Optum, or retailers such as Amazon or CVS. So physician markets, which are traditionally were more competitive, are becoming highly concentrated and vertically consolidated through the rapid increase of hospital and corporate acquisitions of physician groups. And many of these trends are exacerbated by healthcare payment and delivery reforms, which were well-intentioned, such as accountable care organizations or value-based payment reforms, which physicians are seeking and provider groups are seeking to become bigger in order to become able to take on the population health risk and the quality metric burden and the data analysis capabilities needed to be successful in a value-based care environment. However, many of these physician mergers are too small in dollar amount to be reportable under federal Hart-Scott-Rodino reporting thresholds, and so they're too small to be analyzed by or even notified to the federal antitrust authorities. And in many states, they also go unreviewed and unnoticed. So this is leading to a form of what's called stealth consolidation because it's not actually being reviewed in any systematic way. Another form of consolidation is driven by insurance companies. The most prominent example is United Health, which is the largest insurer in the country, but it is also the biggest owner or operator of physician practices. United touts that it has 90,000 affiliated physicians. That is 1 in 10 physicians in the country. It owns the third largest pharmacy benefit manager, and it has its own mail order pharmacy business. It owns the largest healthcare data processing company, Change Health, which was in the news earlier this year for a massive cyber attack that brought the entire healthcare system to its knees. So put simply, it is not only one of the biggest healthcare companies in the country, it is just one of the biggest companies, full stop. And it's not just United that as an insurer, all the other major insurance companies are also pursuing a similar strategy of vertical consolidation. CVS Aetna, the pharmacy insurer behemoth, also operates the largest PBM, Caremark, and spent over $10 billion acquiring primary care providers and home providers such as Oak Street Health and the data processing firms of Signify. So what is driving all of this vertical payer acquisition of primary care practices is the massive profits that are available through the Medicare Advantage program. So I won't get into all the details of that, but Medicare Advantage, which is Medicare's private insurance option, now covers more than half of all Medicare beneficiaries. And while this, this move to Medicare Advantage may be seen as a choice or an option for beneficiaries, it creates a lot of profit incentives through the way Medicare pays Medicare Advantage plans sort of on a per beneficiary capitated basis, which offers a lot of opportunities to invest in primary care practices to grab the patient's data and also be able to maximize payments under the Medicare Advantage program. So while all of this consolidation may be really good for shareholders, it's not so good for the acquired physicians, and it's not so good for the acquired patients or the other practitioners in the community. So the behemoths make it more difficult for independent physicians to stay independent, for independent pharmacies to keep their doors open, because often these large behemoths force them, these independents, to sell or to join the forces, or they'll push them out or undercut them in the market. It's sort of like Amazon comes to town. It's very difficult in the olden days when Amazon just sold books. It was very difficult for a small bookstore, an independent bookstore, to keep its doors open and compete. So all of this ends up as a systemic basis of potentially reducing access and choice of provider. It potentially disrupts patient care relationships, which have been longstanding, and all of these things we see are heightened, particularly in rural areas where things like independent pharmacies, independent practitioners have an important role to play in community access. So what happens when we have a consolidated healthcare system is it drives prices higher. So the main determinant of healthcare prices, and there's a lot of evidence for this, is provider market power. It is not the quality of the care, it is not the input costs, it's not the labor costs, it's not the real estate costs, it's the market power that the actor has. The power to drive up prices is what is driving price increases across the country. So the consolidation wave continues, as I mentioned, horizontal, vertical, cross-market. And all of this consolidation has the result of increasing market power, which then drives up prices for those dominant health systems and healthcare consolidated giants. Yet the higher priced healthcare system is not better quality. So the dominant systems that can command sky-high prices are not necessarily performing at a much better level to justify their higher payments. So all of this excess healthcare spending from high-priced providers is buying us neither more nor better healthcare, quality healthcare. So who pays for these prices? There is strong evidence that in the commercial health insurance market, the higher healthcare prices from consolidation are passed on dollar for dollar to workers in the form of higher premiums and out-of-pocket costs, and these are all taken directly out of wages. So wages are not rising anywhere as fast as they would be otherwise because of the rising cost of healthcare driven by healthcare consolidation. Moreover, researchers have begun to found that these increasing healthcare jobs costs actually cause employers not just to increase the cost of providing healthcare to their employees, but will actually cut jobs, will especially working and middle income jobs, in order to account for the rising costs of providing healthcare to these workers. So here's just a quick slide. It's not the full evidence, but it's just a snapshot of some of the evidence of the impact of consolidation. And the reason to be concerned about all this healthcare consolidation is its well-documented effects on prices and on access. So healthcare hospital mergers lead to significantly higher prices. We've known this for decades, double-digit price increases, particularly in highly concentrated markets. And we know almost nearly all hospital markets are highly concentrated. Horizontal physician consolidation also raises prices significantly, as does vertical hospital acquisitions of physicians. These are all documented, again, to lead to double-digit price increases. So what about all the efficiencies and quality improvements from the vertical acquisitions of hospitals and physicians to form integrated delivery systems, to form accountable care organizations and the like? Again, there's very little indication that there is any economic efficiency being derived from this. Instead, it seems primarily to be driving up costs in this space. There are associated higher prices for both the hospital side, the acquirer, and also the physician side. And there's also, in the context of cross-market mergers, we see that the buying hospital, the hospital that is growing its market power, also tends to increase prices, again, in double digits, depending on the market conditions of that cross-market merger. So it is just increasingly true that we see this across the hospital and physician context, and we're also starting to see this in the private equity context. So when private equity acquires physician practices, prices increase by 11%. Service volume, so utilization, also increases, and all of this is done with fewer or a different level of staff. So what about the effects on quality? So all of the evidence of price increases tend to be pointing in the same direction, or nearly all the evidence. But the evidence on quality is somewhat more mixed. So at the very least, what we can say is that there isn't strong evidence that consolidation or integration increases quality or improves quality. And in some cases, it might even lead to declines in quality. In particular, in the private equity space, work that's been done on private equity acquisitions of hospitals and nursing homes. So these are facilities that rely heavily on nursing staff and other staff. One of the tactics that private equity uses, and Lauren will get into this in the second session, is to reduce staffing levels to save money in order to improve profits. And so what we've seen is in the nursing home and the hospital context, that quality has there is a dramatic effect on quality when private equity acquires these facilities, including a 25% increase in hospital-acquired conditions. These are adverse events. And then in the nursing home context, a shocking 11% increase in mortality, largely due to staffing cuts. All right, so if we are concerned about all of this consolidation, about the corporatization and the potential risks to the healthcare system, even as this evidence is rolling in, we're starting to hear more and more states clamor for policy tools. For the states that are dealing with consolidation, a lot of this is happening, again, and they're hearing about it from constituents, whether it's hospital mergers or whether it's vertical consolidation. But increasingly, states are also concerned about the effects of corporate consolidation within their state. So I'm going to discuss 4 main policy options today for states to deal with corporate consolidation in healthcare. And the first 3 are part of an updated NASHP model law that we worked on this past year for states to address corporatization, consolidation, and healthcare closures that are all driven by these trends. And the 4th policy option is an existing NASHP model for banning anti-competitive health plan contract provisions. But since Nevada is one of the state leaders in this area, I'll be in some ways looking forward to hearing from you how this is going. So the first 3 policies are somewhat, either they're new or they're building anew on an existing model that NASHP has been working on for quite some time. And the first part of it involves healthcare transaction oversight authority. And this is creating a strong authority to review and potentially even block or place conditions upon pending healthcare transactions. So this is, again, with an eye to either preventing or placing oversight over consolidation as it happens. And then the second policy is for states to increase the protections for physicians and other independent healthcare practitioners from the growing corporate controls that they are being put in through these consolidations, whether it's by health systems or private equity or payers. These include the strengthening of the corporate practice of medicine doctrine, but also putting in place stronger prohibitions on physician non-competes and gag clauses. The third policy addresses the lack of transparency into just the extent of the ownership and control relationships that healthcare entities are in today. Without this information, frankly, it is difficult or impossible for regulators, for enforcers, for policymakers, and even for researchers to understand the effects of corporatization, even the extent of corporatization within your area. And then the 4th policy takes aim at already consolidated markets, where dominant providers or payers use their market power to engage in anti-competitive contracting practices that are driving up healthcare costs, again, without improving quality or access or value. All right, so let's dive into this first policy tool. The first policy tool is a policy of enhanced transaction oversight. So the policy concern here is that many states have inadequate insight and oversight authority to prevent and monitor healthcare transactions that are contributing to consolidation and leading in many instances to the closure of key facilities or services, particularly those that are less profitable, like labor and delivery services, and address the type of extractive financial arrangements like sale leaseback arrangements of real estate, of hospital real estate or nursing home real estate that can really undermine the stability of a healthcare system. So to address this, several states have expanded the authority of their state, usually in the Attorney General's office, but also in combination with some other health agency like the Department of Health or a healthcare cost commission, to oversee transactions beyond those typically reported to federal and state antitrust authorities. This is done in two primary ways. The first is to expand oversight authority. This is to say we are going to require a larger scope of transactions to have to notify state authorities when they're going to happen and have a sort of a holding period before the transaction can close.
Yeah, I'm in.
Do I need to pause? So this,
You're fine.
Okay, I'll continue on then. The expanded oversight authority requires this prior notice so that the authorities can be alerted to the transaction, gather information and reporting about key information about the transaction, and potentially, if they think the transaction merits it, review the transaction in a more granular way to make sure that that they can assess the market impacts and the healthcare impacts of the transaction. And then in some states have gone even further and enabled the authority, whether it's the Attorney General or the health agency, to block or impose conditions on the transaction without having to go to court to seek a court order. So this would streamline the process of really stopping really problematic healthcare transactions or placing conditions on those transactions to subject them to stricter controls moving forward to make sure that the risks aren't realized. The second way that states have expanded this oversight authority is, again, to expand the role of the state health agency. So make this be, what the idea is, this isn't just a concern of the Attorney General's office, which has expertise in antitrust and consumer protection and charitable trust doctrine for nonprofit hospitals, but other state agencies, including the Department of Health in many states, have more expertise on impacts of these transactions on things like the healthcare workforce, quality, access, equity, and other types of concerns that are equally of concern to the communities. So if the state health agency has a role in studying these transactions or making recommendations, a more fuller picture begins to emerge of what the potential risks are for some of these transactions. So what the NASHP model that was just released does is it sort of updates an existing model policy that NASHP had previously released for states to strengthen healthcare transaction oversight. And that original model was based in many ways on Oregon's groundbreaking healthcare market oversight authority. And then we recently worked on it to update it for some new challenges that states are facing that we thought weren't fully addressed, or at least not clearly addressed in the original model. And so here are the things that are in the updated version. So first, the 2024 version expands the scope of entities covered. In a lot of these state oversight laws, the original intent was really to capture the forms of healthcare consolidation that we were most commonly seeing a few years back, which included hospital consolidations or hospital physician acquisitions, but really didn't explicitly address the role of, say, private equity in creating management service organizations to acquire controlling interests in lots of physician practices, the use of private equity of real estate investment trusts, again, to strip assets of facilities and real estate from hospital facilities or from nursing home facilities and lease them back to those providers. Also, the increasing role of payers, the Optums of the world, and staffing companies and the like. So it expands the scope of entities to make sure that all of those entities are explicitly covered. And then it also expands the types of transactions, not just a merger or an acquisition, but also the types of transactions that would require notice and review would include sale leasebacks of key assets like real estate, management services agreement that private equity and payers use to manage and control physician practices without outright ownership. And then allow maybe serial transactions, lots of transactions that are maybe too small to even cross the threshold for state notice to be accumulated into 5-year, sort of a 5-year time period, so that the state can look back and assess a transaction if the overall cumulative impact of all of these serial transactions crosses the threshold. Again, closures of key facilities or service lines could also be contemplated as a type of service, type of transaction that must be notified and reviewed, studied, and made recommendations about as well. So it also includes stronger enforcement authority and clarifying the roles of the state attorney general, the state health agency, and provides for ongoing monitoring of transactions that are allowed to move forward. The second piece of this policy is the strengthening of the prohibition of the corporate practice of medicine and other protections for physicians and other independent practitioners. So the policy concern here is the corporate control over physicians and independent practitioners by the private equity firms, the management services organizations, the payers, and the other sort of corporate actors that are flooding the physician market with capital and services, but also in exchange for that control and frankly, more control than I think physicians who might be selling to these practices or selling control of their practice to these entities are really realized at the outset. So the corporate practice of medicine doctrine is a long-standing doctrine. It exists in many states that generally bans unlicensed lay entities, a corporation, from owning, employing, or controlling a medical practice. And it stems from the ban on the unlicensed practice of medicine. So I just want to clarify that the corporate practice of medicine doctrine does not address corporate or for-profit control of hospitals or facilities. It really is targeting, again, this idea of the licensed physician or licensed practitioner. So why does it need strengthening if it's on the books in many states? Well, corporate practice of medicine laws have been eroded over time, coinciding for many years and decades with the rise of managed care. There was sort of a feeling that the corporate practice of medicine doctrine was antiquated and unnecessary. And as hospital employment of physicians increased, there was a lot of non-enforcement or large carve-outs created for hospitals and others to employ physicians. And frankly, clever lawyers have been advising physician groups and their investors on how to circumvent the corporate practice of medicine doctrine through contractual agreements. This is the growth of the management service organization, is this company that exists on paper to provide administrative services for the physician practice, but in essence, when you actually look at the contract, seizes control over all the assets and important decisions of the practice. In a way that usually, in some ways, exerts de facto, even if it's not de jure control over the practice. And often these management service agreements, management service organizations or MSOs, install a friendly physician, someone who is licensed to practice in that state, but who is really just a corporate manager to be the nominal or on paper owner of these practices. And that person is on the payroll of the MSO and is really at the behest of the management service organization. And then that person and the MSO essentially controls the practice through this paper owner. So how do we strengthen the corporate practice of medicine doctrines to address the management service organization, the PCMSO contract? So states are considering these options of how do we get at this sort of current and new form of management service organization. Sometimes the laws that are on the books are just unenforced, or there may be some sense that they are unclear because they were based in a judicial opinion or a longstanding attorney general opinion. So it's important first just to restate the core prohibition, if you're a state, of the corporate practice of medicine doctrine, which bans corporate lay entities, again, from owning, employing, or controlling physicians. But second, and the most, I think, key innovation here is that states can regulate the PCMSO's contractual arrangement. They can, for example, prohibit dual ownership, that someone cannot be a shareholder or a director or a manager in both the practice and the MSO, and require physicians who actually provide services and care within the practice to maintain ultimate control over the clinical and business decisions and administrative decisions that affect the clinical practice. Does this mean that physicians suddenly have to do all of their own billing and coding, that they have to do their own HR, that they have to procure their own supplies? No, we know that there's a lot of administrative work that goes into operating a physician practice that they do need legitimate administrative services for. But what this does is it would restore the principal-agent relationship so that the physician practices are the principals and the MSO is their agent. The MSO works for the physician practice, not the other way around. And then the model also names and sort of enumerates explicitly what types of decisions cannot be controlled by the MSO in order to preserve this line between physician and clinical autonomy and professional decision-making with corporate control. And then finally, there's this idea that non-compete clauses, non-disclosure agreements, non-disparagement agreements that are considered gag clauses are also being used against employed physicians, and frankly, to keep them from seeking employment elsewhere, locking them in, or keeping them from speaking out if they are unhappy with or disagree with the way the MSO or the corporate entity is running the practice. And so to free physicians, whether they are employed or whether they are simply part of a practice that is subject to an MSO arrangement, from being subject to non-competes or gag clauses, can again shift the practice in a way that raises professionalism, raises protections for the physicians to make decisions that are based on professionalism, patient care, and quality concerns. The third piece of this omnibus law that we worked on with NASHB is to create transparency of ownership or control. You cannot regulate or manage what you cannot see. Currently, there is no comprehensive public data source to answer the basic question of who owns or runs my doctor's office. Is it a private equity owned or backed practice? Is it Optum? Researchers have used manual Google searches, expensive proprietary databases, and some combination thereof to try to get a sense of the degree of private equity penetration. And it's even harder to figure out which doctor's offices are affiliated with or controlled by Optum. So if you're a patient and you want to look up this information, there is no place where you can find it. If you're a policymaker and you want to know, well, how many of my physician practices are Optum owned or private equity owned, it's very difficult to get a number or a handle on the extent of corporate control within your area. So the policy here is to require all existing providers licensed in the state to report information about their ownership or control entities, including the web of complicated contractual affiliations and corporate common control entities that might exist. So this helps to create a baseline mapping of all the relationships and figures, and we can then trace, ideally, a particular physician or physician practice or provider of any type, all the way up to its ultimate control entity or owner. So the NASHB model builds on the Massachusetts Provider Registry model, but it would apply the ownership transparency or control transparency to all sorts of healthcare entities, group practices, hospitals, health systems, but also insurers, PBMs, right? Because these are all part of the consolidated, vertically integrated space. We want to know what the relationships are between all of these entities. The required information needs to be granular enough that, again, it can't be obfuscated under sort of, one level of reporting. And so it has to be granular enough to be able to answer that question of, is my doctor employed or controlled ultimately by, fill in the blank? All right, so I'm going to talk just briefly about the ban on anti-competitive health plan contracting before I open it up for discussion. So in Nevada, I don't really have to say too much about this policy because, frankly, Nevada has been one of the national leaders on this front. But for those of you who are maybe unfamiliar with the policy, in short, the ban on anti-competitive contracting practices is a way to contain the contracting tactics that dominant healthcare providers and insurers use to cement their market position. So these include all or nothing contracts. If you want our must-have hospital, you have to take everyone in our healthcare system. anti-tiering, anti-steering provisions that prevent the health insurance plan from building a tiered network or steering patients to high-value providers, and also to figure out how to prevent gag clauses or other contractual provisions that don't allow the disclosure of price information, again, to beneficiaries or to patients. So I think that these are all again, tactics that are used by dominant systems, dominant health insurers, to cement their market power. And so states have been innovating ways to address this. And Nevada is, one of the leaders here, as we note on the slide, banning all or nothing contracts, anti-tiering, anti-steering, exclusive contracts between insurers and providers. So what I would love to do, rather than tell you about this policy, is to ask in the Q&A how things are going. If anyone is aware of how compliance has been, how monitoring is going, and if you're starting to see it make a difference, or evasion, whether there's regulatory evasion, or if it frankly is one of those things that it remains to be seen, whether it will have a large impact. And the last slide I'll just leave you with are just a bunch of state examples. So we didn't draft any of this in a vacuum. We have lots of state examples, either laws that were passed that by states, or laws that have been bills that have been introduced in some legislatures, even if they haven't passed. Were all examples from which we drew the language for the model law. So I'm going to stop sharing. I think the slides will become available to the attendees. So I'd be happy to answer questions.
Thank you so much. This is terrific. And I'll lead it off with a question from one of our members of our audience. And healthcare consolidation may be causing some inflation. However, healthcare inflation has been the second largest inflation industry since 1985. Doesn't the impact of the government as a payer and regulator play a vital role?
Yeah, so I think that when, it's a difficult question to study, because it sort of is like compared to what, whether you're comparing healthcare inflation to other market basket items, goods and services, or whether you're comparing healthcare price increases relative to what the same thing or service costs in another country. But all of it, I think at the end of the day, yes, there's multiple drivers of rising healthcare costs and prices. But I think that the single largest driver is market in consolidation and market power. Yes, there are some indications that there are other factors that contribute to it. New technology advances, particularly in the pharmaceutical space, can of course increase prices and spending there. But I don't think that the presence of government payment, for example, the Medicare and Medicaid program, has contributed, at least in a meaningful way, to the inflationary trend of commercial healthcare prices. If anything, the evidence appears to be quite the opposite. When Medicare cuts price payments, commercial prices actually go down. So there's very little evidence for what's called cost shifting, the idea that hospitals and providers need to charge more to the commercial market in order to make up for Medicare, Medicaid shortfalls. But I think that there's a lot of empirical evidence that that's just not the case. And if anything, the thing that's driving healthcare spending in the commercial sector higher tends to be these other factors like administrative burden, the cost of dealing with multiple payers, dozens of commercial payers in many instances, plus the market power.
Thank you. Another question. Anecdotal evidence from physicians and recent findings from studies like those published in JAMA and Health Affairs suggest that healthcare integration improves patient outcomes and enhances care coordination. And you mentioned some of the value-based initiatives. How do you reconcile this with your position that integration does not lead to better patient outcomes and actually increases costs? How can healthcare organizations better manage risk and improve clinical outcomes if we continue to have fragmented healthcare delivery systems?
Yeah, so I think that there is, I think that, like we said, that the evidence on care coordination and quality is mixed. So there is some evidence that particularly physician-led accountable care organizations, some of the more sophisticated accountable care organizations can generate improvements in quality, either with a small savings or maybe no savings. But I guess if that quality improvement or care coordination improvement is there, then that's a meaningful gain, even if the program as a whole doesn't save a ton of money. I think what we're seeing, though, is that overall, it's hard to make a generalization that all ACOs, all value-based care models, all integrated delivery systems lead to quality improvements. Some do, and some don't. And so the question is, how do we generalize policy recommendations when the whole market is sort of very, there's a lot of heterogeneity within the market. And also what we see is that there's pretty clear evidence that this vertical consolidation, particularly hospital physician consolidation, leads to price increases. So I think we have to question the promise of efficiencies. I think a lot of these entities will tell regulators, we're going to achieve savings, we're going to achieve efficiency and economies of scale, better care coordination, less waste. And then when we actually measure it a few years later, it looks like that the opposite has occurred. Maybe that there is more care coordination, but the larger market power is leading to price increases, not price reductions.
Okay. Our next question, in my experience, especially in the Pacific Northwest, faith-based, not-for-profit entities like Providence and CHI drive consolidation, in part due to favored tax status, enabling anti-competitive mergers and acquisitions and service lines. Appreciate your comments.
Yeah, so I think that that is a flavor of consolidation that is happening. I think it's, cross-market consolidation that is, frankly, I think there are a few good studies out there that are starting to show just the size of some of these Catholic health systems in particular, which raise additional concerns about access, not just in terms of the typical consolidation concerns when it comes to price increases, market power, et cetera. But the ability, the fact that you can have lots of hospitals or lots of affiliated providers, but say a reduction in access overall to certain reproductive care services, certain end-of-life services, and other services that are that go against the Catholic and religious directives of the Catholic Church. So I think that there are sort of as like an additional layer of concern there that goes on top of the typical market-based concerns. And I think that often regulators are not taking that into account, maybe when they're looking at particular access issues. And I think that's an area where a state health department or healthcare agency that has a much better sense of these real on the ground clinical implications and access and population implications of these mergers, it's really helpful to add to the, frankly, price and cost and market power, market concentration analysis that antitrust usually takes. So I think having both inputs is really important to understand the true effect of some of these consolidations. And that's a great example.
Thank you. I have a question while we're waiting for more attendee. When we look at other countries, a common, maybe even universal, is government rate setting, and maybe a more direct way of getting at the problem. Do we know how these kinds of, trying to reduce the effects of consolidation, those kinds of strategies compare to rate setting and effectiveness? Are they equally effective, or is it more of a political choice?
I don't know if I've seen sort of a head-to-head comparison. I think in everyone's mind, perfect competition is always going to do a better job than government regulation, but we don't have perfect competition. We don't even have imperfect competition, frankly, in most of the healthcare market. And so then the question is, what do you do then? So usually there are really just two big policy tools to use to address consolidation in any given market, not just healthcare. One's antitrust. So one is to prevent consolidation or even break up ill-gotten consolidation or monopolization gains. Or the other is to set rates. So once you have legally acquired monopolies, it's very difficult to break them up. It's very difficult to reverse those, to reintroduce competition. So if competition policy can't actually restore competition, and you're left with a consolidated market, then I think the other option is some form of rate setting, which can look different across, different countries and different methodologies. But I think that is sort of in many parts of this country and certain market segments is sort of where we're headed. I mean, I think we're getting to a point where we're not able to reintroduce sufficient competition to have market forces do the job of constraining prices.
I'll ask another question while we're waiting for audience. As a legislator here in Nevada, I haven't seen employers, of course, are very concerned about the cost of healthcare for their, and they point to how much it drives up their costs and affects their competitive, how they are able to compete with other companies, especially overseas. Yet they don't always seem as enthusiastic about reforms as you would expect from their expressions of concern. Do you have any thoughts about that?
Yeah, I think that, I think employers and purchasers are sort of really important voice in all of these policy debates, as you mentioned, because most people in this country, or at least the largest market segment of people in this country, get their insurance through their employer. So the employers play a huge role in providing healthcare coverage and negotiating costs on behalf of the employees, and labor unions also do this as well. And so that sort of experience as a patient, as an individual consumer, I don't know the cost of any given healthcare service or item. I am relying on, my employer, and frankly, the employer is then relying on third-party administrators or other consultants, brokers, middlemen, pharmacy benefit managers to further negotiate on my behalf. And I think one of the concerns is that employers feel in the dark, even though they have such a big seat at the table. You'd think they have all this bargaining power, but they say, one, they don't have a ton of bargaining power when it comes to the big healthcare systems in their area, that they need to include them, or the HR department will, say that our employees will go crazy if we lose access to the key providers or key facilities that our employees need access to. So they're not always in a great bargaining position, even if they have, billions of dollars to bring to the bargaining table. But the other thing is, I think that what I'm hearing more and more about is that employers don't have as much information as they need to make these decisions. They're not seeing their prices. They don't know how much their third-party administrator or their consultant or broker fees or multi-plan is a repricer. All these middlemen are sort of taking along the way. And so they're sort of just relying on this black box to do the negotiating for them. And the entities in that black box have financial interests of their own, which are often counter to both the employer and to the ultimate patient. And so I think a lot of this ends up getting very muddy, and employers don't exactly know what their power is, or they don't know how to wield that power because of this sort of complexity of the third parties that are involved, that stand between them and their healthcare providers. So I think that's, which isn't to say that there aren't some motivated employers or purchasers or unions that are really involved in this struggle. But I think that the first step is to get employers a true sense of like how good of a deal are your TPAs getting for you? What are your prices? Are you getting passed on the best prices that you could? Particularly because the employer is the one who, frankly, is self-funding or footing the bill and passing that on to their workers. And so it affects their competitiveness in the labor market.
Thank you. You've given us a great menu of policy options. Are there policy options that are popular that you would want to advise us not to pursue, that they aren't effective or counterproductive, yet are commonly discussed and even adopted in some states?
I don't know if I would say that any I think we need a more robust policy evaluation system to really say like, well, that doesn't work. That does, that's a terrible idea. Sometimes we learn, further down the line that some things have unintended consequences, but it's like, it's sort of like the vertical integration. Yes, there are, it's well-intentioned, there are some good policy goals, but along the way, we find that moneyed interests use those opportunities to generate profit for shareholders. And so I think that one of the things that I would probably comment on is maybe not a silver bullet, but you find it in part of every policy conversation is transparency. And so I just want to say something quickly about transparency. One is price transparency is one form of transparency. There are other forms of transparency. I talked about ownership transparency today. There's also things, billing transparency, other types of transparency. I think one of the arguments can be, well, transparency is bipartisan. I think there's almost no one who argues that healthcare costs and all of these the prices, the financial relationships should be more opaque. So I think that, transparency is bipartisan. So there's often a lot of agreement, or there can be more agreement among policymakers that we should improve price transparency. I think that the mistake is to misunderstand what it's for. Price transparency has in the past been sold as itself a solution, in the sense that like, well, once consumers or patients know what something's going to cost, then they will shop for, the cheaper, more high value MRI. Arm people with information, and they will act like consumers, and then consumer directed healthcare, give them a high deductible plan, make it give them more skin in the game, and they will shop more effectively, and that will drive down healthcare prices. And I think there's very little evidence that patients use this pricing information in that way. Healthcare is just not shoppable enough, and we're too vulnerable. We know too little about what we need. We rely on the recommendations and the referrals of our physicians and our nurses, and that's I don't think that is changing. However, that's not to say we should throw up our hands and not pursue transparency of all of these things. And the reason is we need transparency. Who needs it? The regulators, the enforcers, the policymakers, the researchers, that's who uses that information to be able to evaluate what are the trends, what happens, what's the price effect of any given, change in the market or any given transaction. We need to know that information. So I think that price transparency is one of those things where it's a necessary starting point. It is not the end of the conversation. I'm not against price transparency, but I'm against the idea that it will in itself solve any of these problems.
Well, thank you. We're just at the end of time, but I'll do one final question if you want to quickly comment. Recent experience with HCA understaffing physicians, promoting burnout and turnover, national policy to avoid physician employment and favor third-party contracting, shifting economic and liability risk while stock prices soared in recent past. You've certainly discussed these concerns. If you want to make any final comments about that or any other closing remarks.
No, I mean, I think, it's just, I don't know if other than if I have any other further comments or, other than to say, yes, there's a lot of examples of this and of these dynamics showing up. And I think that, I see some of the questions coming through that make it look like, oh, you're missing this other big trend. It's like, yes, it's all part of the same, phenomenon. And wherever you look, you might see this occurring. So yes, I encourage everyone to continue. If you have questions, reach out. If you have any thoughts or ideas for me, I would be happy to engage. So thank you so much for having me. It's been a pleasure.